In South Australia, as elsewhere, only a fit and proper person can hold a liquor licence. In this case, a man named Gennady Krasnov applied for a licence to operate a new karaoke bar. Applications of this type are publicly advertised. The Commissioner of Police in South Australia made a submission to the Liquor Commissioner that Mr Krasnov was not a fit and proper person. However, the submission was made on the basis of criminal intelligence, which is defined by statute as information relating to actual or suspected criminal activity, the disclosure of which could reasonably be expected to prejudice criminal investigations or to enable the discovery of the existence or identity of a confidential source of information. Where criminal intelligence is provided to the Liquor Commissioner, the legislation provided specific rules for keeping that intelligence confidential. The legislation said no information provided by the Commissioner of Police to the Liquor Commissioner may be disclosed to any person except the Minister, a court, or a person to whom the Commissioner of Police authorises its disclosure if the information is classified by the Commissioner of Police as criminal intelligence. On the basis of the Police Commissioner's information, the Liquor Commissioner refused the licence. The applicant was never shown the criminal intelligence and was never given an opportunity to respond to that material. This is contrary to procedural fairness, which requires that a person should have the opportunity to know and respond to the case against them. The High Court confirmed that the Parliament can abrogate procedural fairness, and Chief Justice French identified the reason why suppression of criminal intelligence has public value. He said, as a practical matter, it may be highly unlikely that relevant confidentiality could be assured if information were to be disclosed to an applicant adversely affected by it. However, he did make the point that the decision maker should bear in mind the fact that the applicant has not had the opportunity to test the criminal intelligence. He said, there is nothing in the Act to prevent the court from taking into account the fact that the information has not been able to be tested by or on behalf of the applicant in assessing its weight. From this case, we confirm that procedural fairness can be abrogated by statute and that the protection of criminal intelligence sources is one of the key reasons that this might occur.